And our next speaker, Mr. President, please, Troy LaRaviere, CPAA President, followed by our first speaker of the speakers list. Mr. LaRaviere.
Good morning, beautiful people. Can you hear me?
We can hear you. You can proceed, Troy.
Thank you so much. In July of 2019, a principal who I'm going to call Michelle filed a complaint with the CPS Inspector General alleging that her supervisor created a hostile and verbally abusive work environment. For example, he's accused of having cultivated relationships with dissatisfied parents and showing up with the parents at Michelle's school with no prior notice to undermine Michelle's ability to address the parents' concerns. On one such occasion, he said to have kicked Michelle and 2 staff members out of the room to hear the parents' complaints by himself, then summoned the staff back to the room only to berate Michelle for the parents' accusations without ever giving her an opportunity to refute or respond. Now, I'm going to quote what at least 3 witnesses allege this supervisor said in writing. They said, these witnesses said in writing what he said to Michelle after excusing the parent from the room. The quote contains harsh language, and I will repeat it uncensored. I understand and apologize if it is offensive, but I do not want to portray the vile and abusive mindset behind this statement as anything other than what it truly is. After excusing the parent, he told Michelle in front of witnesses, quote, "You know I'm a nigga, right? You know I'm a nigga, right? I don't want no shit from y'all in this school," unquote. That same year, he stated to Michelle in the presence of other witnesses about the Black school community, quote, "These are my people and y'all ain't shit. Get the fuck out my face," unquote. After reading these statements, I sought out several administrators whom I knew worked for this particular supervisor, and based on their statements, it seems that he picks and chooses his targets. Some had no problems with him, while others gave detailed stories of abuse as bad or worse as what I've already described. It was not my responsibility to investigate Michelle's claim, but I did. But unfortunately, the Inspector General did not do his job. Michelle's complaint sat in the OIG's office for over a year, and they did nothing, even after she filed a second complaint detailing the supervisor's abusive conduct in retaliation against Michelle for filing the first complaint, which is illegal. It wasn't until our general counsel began to push the Inspector General that Michelle was even contacted. And that is when an already alarming story about this allegedly abusive supervisor gets even more disturbing. Instead of investigating the matter himself, the Inspector General referred the case to the law department, and they reached out to Michelle for an interview. Before that interview with the law department, an AUSL supervisor named Jarvis Sanford sent a disciplinary meeting notice to Michelle with an investigative report compiled by the law department related to a complaint against Michelle. In that complaint, Jarvis Sanford is the only witness against Michelle other than the complainant, even though he had no direct knowledge of the allegation. I need you all to see what's happening here. Just before the law department was supposed to question Michelle about her abusive supervisor, they allowed Jarvis Sanford to basically serve as a character witness against Michelle in a case that he likely orchestrated against her. Why is this important? Because Jarvis Sanford is the allegedly abusive supervisor. So the law department finally calls Michelle to supposedly investigate her complaint against Jarvis. Then they work behind the scenes with Jarvis to compile an investigative report against Michelle. It seems that not only is CPS not investigating the claims against Jarvis, but his retaliation is being aided and abetted by your law department. And for the record, that is illegal. And in CPS, who gets to make the decision about punishing Michelle after this disciplinary meeting orchestrated by your law department? Jarvis Sanford. So problem number one is that Sanford's going to decide Michelle's fate based on an investigative report that he helped shape with the assistance of the law department that is investigating Michelle's complaint against him. Problem number two is that in CPS, one man gets to be the witness, the judge, and the jury with no recourse for the defendant. For a public school principal, CPS is like its own totalitarian world, where the basic due process provisions of the United States Constitution don't apply to how they get treated by district management. This isn't the first time Jarvis's name has come before this board. At one of your very first meetings in the summer of 2019, he was brought to your attention after being accused of violating the rights of the local school council at Michelle's school by refusing to post a principal vacancy and delaying the principal selection process so that they could not give Michelle a contract. And it was only after the LSC appealed to you, this board, that Jarvis was compelled to post the position. You protected the rights of the LSC, but you ignored the rights to health and the safety of the principal, even though the LSC told you in writing that they felt Sanford was treating Michelle unfairly. In conclusion, the purpose of the Chicago Principals and Administrators Association is to ensure our members have the resources, working conditions, and policies they need to help their students reach their full potential. In CPS, that often means fighting to remove the obstacles in the way of this goal. And if these allegations are true, then Jarvis Sanford is one of those obstacles, and so is your law department. We don't ask you to believe. We ask you to investigate. Remove the law department from this case and hire an independent firm to investigate the allegations against Sanford. Then hire a second firm to investigate the conduct of your law department. Now, that was the end of the statement that I came to make, but I'd like to take less than a minute to acknowledge something that the district did today in relationship to principal compensation. Just a couple of months ago, the talent office announced that there would be no raises for principals and APs. Then I came before this board and made you aware of the fact that your administrators, who are majority non-white, are making less than the majority white teaching force that they supervise. And this is an extreme danger to the principal pipeline. By reversing course and deciding to give administrators raises similar to the ones you'll give teachers over the next 4 years, you have ensured that this picture doesn't get worse. But you've done absolutely nothing to change that. That is an objective fact. In 4 years, assistant principals who are majority people of color will still be earning less per hour and in many cases less in total earnings than the majority white teaching force they supervise. This is a time bomb for the principal pipeline. So while what you did today was appreciated, and I mean that, the time bomb is still going to go off if there is not an across-the-board salary adjustment at some point in the next couple years. We look forward to working with you to address this impending crisis. Thank you.
Thank you for your comments. Mr. President.